Hello, dear MEDDIC academicians and partners of MEDDIC Academy. Today, I want to address an unusual subject. Over the past few years, there has been a legal dispute over the MEDDPICC trademark. There are always two sides to every story. I don't want to litigate this case on social media, obviously, but I do want to explain my side. Because the matter was taken to social media after the interlocutory ruling, I felt I had no choice but to address it publicly. So clients, partners, and the sales community can hear my side of the story and make their own judgment. So what is a trademark? Why did I trademark MEDDPICC? And what is in it for clients, consumers, and partners? Why should they care? A trademark doesn't give anyone ownership of a methodology or an idea. A methodology or an idea is not protectable. People are free to practice it, discuss it, improve it, or teach it. The purpose of a trademark is different. Trademarks are primarily designed to protect the customers from being confused about the source of goods or services, in our cases, online courses. It also protects a provider who uses a symbol or a name in commerce to identify the source of a product or service, not the concept, the idea, or the methodology, but the product or service. It avoids confusion, protects trust, and helps define standards. That's why there is a difference between discussing or using MEDDPICC as a methodology and selling courses, products, apps, workshops under that name. Anyone can teach sales qualification. Anyone can even teach MEDDPICC inside a course called sales qualification. But naming your commercial offer the same as someone else's commercial offer creates confusion for the clients. Trademarking courses about the methodology is common. Six Sigma, for instance, is a methodology, but Six Sigma courses and certifications are protected by trademark. The same is true for spin selling in sales, Kaizen in operations, ITIL in IT services, Prince 2 in project management, or SAFE in agile development. Also, a trademark has a lifetime. It has to stay alive. And for that, the owner not only has the right to enforce it, but the obligation. So why did I trademark MEDDPICC? My goal has never been to silence the community. We have obviously never prevented anyone to use MEDDIC or MEDDPICC. My goal has been to bring clarity and quality standards to the market. We offer licenses to trainers, MEDDPICC trainers, at a very low fee, but we examine their knowledge very seriously before certifying them. Before MEDDIC Academy, MEDDIC and MEDDPICC existed primarily as tribal knowledge. They were known in some circles, taught inside some companies, and interpreted differently by different people. Even basic definitions were not always consistent. For example, I believe the I in MEDDIC stands for identify pain, but even some of the same people who claim that MEDDPICC is generic have another definition for the I in MEDDIC. This is why codification matters. I have never claimed that I coined MEDDIC or MEDDPICC. Actually, no single person did. In September 2023, with Wickberg of Upsales, John McMahon said this, quote, "The genesis of MEDDIC didn't happen when a couple of guys just sat in a room and came up with it. It was an iterative, organic process. My contribution was different. I helped codify it and structure it. I published it and made it consumable, accessible, scalable, and teachable. 13 years ago, I created the first public educational slide deck on MEDDIC and MEDDPICC and made it available on SlideShare free of charge for everyone to use. That was in July 2013. I'm not aware of any educational slide deck educating on MEDDIC and MEDDPICC before that date publicly. In 2017, I founded MEDDIC Academy. I launched the first full MEDDIC and then MEDDPICC online courses with videos, documents, slides, tests, quiz, tools, apps. I'm not aware of any online MEDDIC or MEDDPICC course or certification available before that date. In 2017, years before filing any trademark, I reached out to John McMahon, Jack Napoli, and Force Management. I offered them to join me building and launching MEDDIC Academy. Jack Napoli was supportive, and we collaborated and co-delivered courses together with his team members. With Force Management, we had months of discussions, but things were moving too slowly, and I decided to launch alone. Later in 2020, I published Always Be Qualifying, the first book dedicated to MEDDIC and MEDDPICC. Again, I'm not aware of any book teaching MEDDIC or MEDDPICC before June 2020. MEDDIC Academy has now trained professionals and companies in over 132 countries. We also shaped the Google Trends graph. That work helped bring MEDDPICC from scattered tribal knowledge into a global education ecosystem. When you build something like that, protecting the name means caring for the clients. They deserve to identify the product, hear the courses without confusion. It's not about ego or stopping others. It's about protecting customers from confusion and making sure they know whether a course, an app, a tool, a workshop is from MEDDIC Academy. Now, after years of investment by MEDDIC Academy, a UK company entered the market a few years ago. It was founded by someone who had not been at PTC. In my view, he named his company very similarly, and he named the title of his courses very similarly as well. So yes, I reacted. As the trademark owner, it was not just my right, but my obligation to react. If a trademark owner knowingly allows unauthorized use, the mark weakens over time. Many other companies took a license at a very reasonable rate, and we collaborated with them. But this company took a different route. They registered MEDDIC with 2C, MEDDPICC related trademarks in the UK and in Europe, and today they still hold them. They even enforce them against third parties to prevent them from using MEDDIC, MEDDPICC, or MEDDIC with 2Cs. And then they came to the US to argue that these terms are generic and shouldn't be trademarked. If their goal was truly to make them accessible to all, would they have filed exclusive trademarks in other jurisdictions? Despite all that, we didn't sue them. They came from the other side of the pond into the US market, they challenged us, and they filed claims against us in a US court. So yes, the interlocutory ruling is not what we expected. We take note of it and will act according to our legal options. But everyone should know that a court ruling is part of a legal process. It doesn't mean every third-party use is automatically fair, honest, or non-confusing. Also, MEDDPICC remains protected in other jurisdictions, including through registration with the French INPI. Regardless of any framing, MEDDIC Academy played an undeniable role in bringing MEDDPICC from tribal knowledge into a global education ecosystem. We will continue to build, innovate, and serve. The legal process is still ongoing, and we will respect it. I believe justice will always prevail in the end. And when it doesn't, it's not the end.